What's going on, good people? It is the Bad Wolf. Once again, your international man of mystery, your man in black. Let's get into it. So this is like what part one, two, three, four, I think, of the treatise on income tax. Let's get into it. Hopefully everybody's doing good. Nothing but positive energy to you guys in your day. All right, roll the tape.
Chapter 4 Construction of Statutes Imposing Income Taxes 29. Rule of Strict Construction. 30 Statutes in Pari Materia. 31 Associated Words and Phrases. 29. Rule of Strict Construction. It is a rule sanctioned by many authorities, and particularly with reference to the revenue laws of the United States, that a statute imposing taxes is to be construed strictly against the government and in favor of the taxpayer, and that no person and no property is to be included within its scope unless explicitly placed there by the clear language of the statute, and no heavier burdens imposed than the plain meaning of its terms will warrant. Point 1. Thus, it has been said, it is an old and familiar rule of the English courts, applicable to all forms of taxation and particularly special taxes, that the sovereign is bound to express its intention to tax in clear and unambiguous language, and that a liberal construction be given to words of exception confining the operation.
Did you hear that? One, they threw out in the that the sovereign is bound to express its intention to tax in clear and unambiguous language. They're telling you you have the right to contest these things if it's not clear. What they're not making clear is who exactly has to be taxed and who doesn't. Well, I'm going to make it clear for you. The sovereign, the state citizen, the national is tax exempt. However, you can elect to make a tax. If you do a taxable activity, something from their creation, they have the right to assume you're taxable. You have the right to rebut their assumption. If you work directly for the government or the state, you are taxable. Your income, your compensation is derived from a taxable source. They don't lay it out in any of this language that clearly. They just go right into these things are all this, this, and this. So it can be contested. Let's keep going.
Of duty. Asterisk asterisk asterisk. We have ourselves had repeated occasion to hold that the customs re American Net and Twine v. Worthington, U.S. Watts, compared, annual laws should be liberally interpreted in favor of the importer, and that the intent of Congress to impose or increase a tax upon imports should be expressed in clear and unambiguous language. 2. It is a general rule, in the interpretation of all statutes levying taxes or duties upon subjects or citizens, not to extend their provisions by implication beyond the clear import of the language used, or to enlarge their operation so as to embrace matters not specifically pointed out, although standing upon a close analogy. In every case, therefore, of doubt, such statutes are construed most strongly against the government and in favor of the subjects or citizens, because burdens are not to be imposed, nor presumed to be imposed, beyond what the statute expressly and clearly imports. 3. If the consideration thus given to the case still leaves the matter in doubt, there should be applied the well-settled rule that the citizen is exempt from taxation, unless the same is imposed by clear and unequivocal language, and that, if there is a fair doubt as to the construction of an act imposing taxation, the doubt should be resolved in favor of those upon whom the tax is sought to be laid. Asterisk. And again, it is a conceded principle that taxes must be imposed by law, and that the law should be construed favorably to the taxpayer and not extended by implication beyond its clear intent. 5. And so, At the outset it may be remarked that a statute providing for the imposition of taxes is to be strictly construed, and all reasonable doubts in respect thereto resolved against the government and in favor of the citizen. This principle is so well established that the citation of any considerable number of authorities in its support is unnecessary. 6-2 Eadman v. Martinez, 184 TLS. 578, 22 sup. CT. 515, 46 L. ed. G97. S. United States v. Wigglesworth, e mutual benefit. Applying these principles to the specific case of income taxation, the rule may be deduced that only those persons and corporations are subject to the payment of the income tax who are specially described in the statute authorizing it or clearly within the meaning of the general terms which it employs, and that if any substantial and reasonable doubt arises as to whether any particular fund or kind or class of gain or acquisition constitutes taxable income within the meaning of the law, it is to be resolved in favor of the taxpayer and not in favor of the government. And so the
Do you guys hear that? Are you hearing this? I hope so. These are your rights and freedoms.
authorities hold. Point 7 Thus, in regard to the Federal Corporation Tax Law of 1909, it was said that the statute, levying as it does a tax upon the citizen, must be strictly construed. It cannot be enlarged by construction to cover matters not clearly within its import. The question is not what Congress might have done or should have done, but what it actually did do. When this is ascertained, the duty of the court is accomplished. 8. And this view is further strengthened by the consideration that the same rule has come to be accepted and applied. In the case of the laws taxing inheritances and successions, which furnish the nearest analogy to an income tax law, such a statute, it is held, must be construed strictly against the state or the government and in favor of the taxpayer, and a doubt as to the taxability of a particular fund should be solved in favor of the citizen. Point 9 F. Foreman v. Board of Assessors, 35 Law. N. 825, Lining v. Charleston, 1 McCord, S. C. 345, Robson v.
So, what you're hearing now on the bottom of these pages, which I usually try to skip over, these are the court cases, okay, the federal court cases and whatever else, where they've supported what he's saying here. These cases or these opinions are the law. It's already been adjudicated in real law. He's taking bits from these things here, which have already been done in law, and made it into this treatise.
Regina, Forter, S. Pennsylvania Steel Co. Estate, 30. Statutes in pari materia. It is a fundamental rule in the interpretation of statutes that acts in pari materia are to be read and construed together. The reasons for this rule have been explained by the present writer in another volume, as follows: all the enactments of the same legislature on the same general subject matter are to be regarded as parts of one uniform system. Later statutes are considered as supplementary or complementary to the earlier enactments. In the course of the entire legislative dealing with the subject, we are to discover the progressive development of a uniform and consistent design, or else the continued modification and adaptation of the original design to apply it to changing conditions or circumstances. In the passage of each act, the legislative body must be supposed to have had in mind and in contemplation the existing legislation on the same subject and to have shaped its new enactment with reference thereto. Hence the same principle which requires us to study the context for the meaning of a particular phrase or provision, and which directs us to compare all the several parts of the same statute, only takes on a broad scope when it bids us read together, and with reference to each other, all statutes in pari materia. Whatever is ambiguous or obscure in a given statute will be best explained by a consideration of analogous provisions in other acts relating to the same subject, or by a study of the general policy which pervades the whole system of legislation. Secondly, the rule derives support from the principle which requires that the interpretation of a statute shall be such, if possible, as to avoid any repugnancy or inconsistency between enactments of the same legislature. To achieve this result, it is necessary to consider all previous acts relating to the same matters, and to construe the act in hand so as to avoid, as far as it may be possible, any conflict between them. Hence, for example, where the legislature has used a word in a statute in one sense and with one meaning, and subsequently uses the same word in legislating on the same subject matter, it will be understood as using the word in the same sense, unless there is something in the context or in the nature of things to indicate that it intended a different meaning thereby. 10. And it is said that the rule of construction by the aid of statutes in pari materia is especially applicable in the case of revenue laws, which, though made up of independent enactments, are regarded as one system, in which the construction of any separate act may be aided by the examination of other provisions which compose the system. 11. And it is not necessary to the application of this rule that the earlier act should still continue in force. Although it may have expired by its own limitation, or though it may have been expressly or impliedly repealed, still it is to be considered and read as explanatory of the later enactment. 12. It has been held, however, in one case, that where a personal tax law imposes a tax on a certain occupation, without defining it, it is doubtful whether the court, in construing it, can look to old and repealed tax laws, which define such occupation, to ascertain the legislative meaning. 13. Now it has been held that all the successive acts of Congress from 1861 to 1867, imposing income taxes, are in pari materia, and are to be construed as one continuous enactment. 14. And of course this doctrine may be expanded so as to include the acts of Congress of 1894, 1909, and 1913. It is chiefly for this reason that all these various enactments have been printed in full in the appendix to this volume, where they may be studied and compared at length. And it follows that it will be a legitimate method of construing the present income tax law, in cases where its language in relation to a particular point or subject is obscure, confusing, or unintelligible. To 10. Black, Interpretation of Laws, 2d ed. pp. 332 to 311 is law. Compare it with the corresponding provisions on the same point in the earlier acts, which may be more clear and precise, and to presume that Congress intended its words to be understood in the same sense as before, unless there is such a distinct change of language as to compel the inference that a change in legislation was certainly intended. So likewise, the income tax law of any given state is to be read and compared, not only with previous income tax laws, if any, but also with all the other revenue laws of the same state, each serving to illuminate and explain the others, in cases where their provisions touch or coincide, and where any substantial doubt arises from the ambiguity of the language employed. 31. Associated words and phrases. It is another ancient and fundamental rule in the construction of statutes that the meaning of a doubtful word or phrase may be ascertained by reference to the meaning of other words or phrases with which it is associated, and that, where several things are referred to, they are presumed to be of the same class, when connected by a copulative conjunction, unless a contrary intent plainly appears. 15. For example, all the acts of Congress on the subject of income taxation, from 1862 to the present time, have associated together the words gains, profits, and income as descriptive of the subject taxed, and the same is true of the income tax laws of some of the states. These words may be traced far back in the history of English taxation. The original income tax law of that country, enacted in 1799, imposed a tax on income by that name, but the Acts of 1842 and 1853 introduced the associated terms profits and gains, whence they were apparently borrowed by Congress in framing the Act of 1862, and have since persisted in use. Applying the rule above stated, we are justified in asserting the following principles as applicable to the interpretation of the phrase in question, if it is doubtful. I.B. Black, Interpretation of Laws, 2d ed. p. 194. Although the disputed item may be certainly a profit, in one sense of the word, yet it is not taxable unless it be a profit. Whether or not a particular fund or acquisition is taxable as income, under the statute, it is not taxable unless it is income in the nature of gain or profit. If any item is clearly included in the description of gains, yet it is not taxable unless it is a gain in the nature of income or profit. And although the disputed item may be certainly a profit, in one sense of the word, yet it is not taxable unless it be a profit accruing by way of gain or income. Chapter V. What constitutes taxable?
Now, that in itself is an amazing little piece. I don't even know if I can really even break this last paragraph down properly. But this is how they try to define it. Did you gain or profit? But did you? This is not a clear sentence. This is not a clear statement. So if any item is clearly included in the description of gains, so this is where they get you with your capital gains, yet it is not taxable unless it is a gain in the nature of income or profit. And although the disputed item may be certainly a profit in one sense of the word, yet it is not taxable unless it be a profit accruing by way of gain or income. Man, it's going to take me a while for my brain to. I get it, but man, that's interesting. All right, let's keep going. Now we're in chapter 5. What constitutes taxable income? Feel free to take a little break or whatever else. Pause the video. Do whatever you got to do. All right.
Income 32. General definitions of income. 33. Profits and gains compared and distinguished. 34. Change or substitution of capital distinguished. 35. Rent of land and royalties. 36. Rental value of residence. 37. Salaries and earnings from professions and trades. 38. Pensions, gifts, prizes, and awards. 39. Legacies and inheritances. 40. Products of agriculture or stock raising. 41. Produce of mines and oil and gas wells. 42. Profits of mercantile business. 43. Profits from unauthorized business. 44. Income from partnership business. 45. Profits on sale of real estate. 46. Profits of sales of securities. 47. Increase in value not realized by sale. 48. Uncollected interest and accounts. 49. Profit to accrue on uncompleted contracts. 50. Profits from sale or lease of patent rights. 51. Annuities. 52. Interest on government bonds. 53. Dividends on corporate stock. 54. Same, stock dividends. 55. Accumulated earnings or undivided profits of corporation. 56. Right to subscribe for new stock of corporation. 57. Sale and distribution of assets of corporation. 32. General definitions of income. Income is defined as that gain which proceeds from labor, business, property, or capital of any kind, as, the produce of a farm, the rent of houses, the proceeds of professional business, the profits of commerce or of occupation, or the interest of money or stock in funds, etc. Revenue, salary, especially the annual receipts of a private person or a corporation from Property 1. It means that which comes into or is received from any business or investment of capital, without reference to the outgoing expenditures. When applied to the affairs of individuals, the term expresses the same idea that revenue does when applied to the affairs of a nation or state. Point 2. The term income, as used in a statute providing that no income derived from property subject to taxation shall be taxed, means the income for the year and is the result of the year's business. It is the net result of many combined influences: the use of the capital invested, the personal labor and services of the members of the firm, and the skill and ability with which they lay in, and from time to time renew, their stock, the carefulness and good judgment with which they sell and give credit, and the foresight and address with which they hold themselves prepared for the fluctuations and contingencies affecting the general commerce and business of the government. To express it in a more summary and comprehensive form, it is the creation of capital, industry, and skill. 3. Again, as this term is used in statutes relating to the nature and ownership of property, it includes the rents and profits of real estate, interest on money, dividends on stock, and other produce of personal property. Point 4. Particularly, when applied to a sum of money, or to money invested in public or corporate securities, income means interest. Point 5. But an important distinction must be noted in the signification of this word, according as it is used in the ordinary busy 1 Monday v. Van Hoos, 104 GA. 625, 30s. E782, Sowards v. Taylor, 42 111. App. 275, Remington v. Field, 16R. I-509, 17 ATL. 551, Thorn v. Debret-Ewell, 86 App. DIV. 405, 83 N. Weisup. 849. 2 Bates v. Porter, 74 Cal. 224, 15 Poc. 732, People v. Board of Supars of Niagara County, 4 Hill, N. Y. 20, Mundy v. Van Hoos, 104 GA. 625, 30s. E782. 3 Wilcox v. Middlesex County, Com. 103 Mass. 544 * Rev. Codes N. Doc. 1899, 3322, Civ. Code S. Doc. 1903, 238, Civ. Code Cal. 1903, 748. 5 Sims Appeal, 44 Pa. St. 345, Pearson v. Chase, 10R. I-455. Ness Affairs of the Community, or in statutes relating thereto, or in a tax statute. In the former case, it is understood to mean net income or profit; in the latter case, it is equivalent to gross income or gross receipts, unless otherwise specified in the statute. Thus, it is said that the word income, as used in commerce and trade, means the balance of gain over loss in the fiscal year or other period of computation, or it is the ultimate profit of a business or trade, ascertained by placing the sum total of gains over against the sum total of losses. Point 6 So, the income of an estate means nothing.
Did you guys hear that? Thus it is said the word income as used in commerce and trade, meaning how they use the word in commerce and trade. So in order for them to have an income tax, you must be in commerce or trade. And it means the balance of your gain over the loss in a financial year. This is why they try to When you're working, they're trying to say that you're either operating in a trade, business, or commerce. But really, when you're working at that company, that's your labor. The company itself is doing commerce and trade. You're not. You're within the company doing labor, trading your time and life force in a labor way for compensation. The company itself is doing commerce and trade. You're not responsible for the company's tax. It is the ultimate profit of a business or a trade. Now, if you're doing a trade for yourself, that's one thing. That's taxable. You're doing something commercial. Are you a business? Are you the business? No. The devil's in the details, guys. They're telling you right here.
More than the profit it will yield after deducting the charges of management, or the rent which may be obtained for the use of it. The rents and profits of an estate, the income, or the net income of it, are all equivalent expressions. 7. So, in a statute providing that a certain railroad company shall be required to make an annual payment from its income to the sinking fund, to aid in the construction of the road, the word income must be construed as meaning the amount of money remaining to the corporation on making up its annual account, after deducting from all its receipts the necessary expense of repairs and management, and also the amount of interest on the debt of the Commonwealth which the corporation is bound to pay in behalf of the Commonwealth. 8. So in a railroad mortgage providing that, until default, the mortgagor shall remain in possession and operate the road and take the tolls, rents, and income, and apply them to the payment of current expenses. The term income means what is left after paying the expenses of earning income. 9. But on the other hand, in a statute imposing taxes, income means gross receipts, not net profits, unless it is so specified. Whenever the law means to tax the clear profits arising. 6. City of Kingston v. Canada Life Assur. Co. 19 Ontario, 453. T. Andrews v. Boyd, 5 Me. 199 S. Opinion of Justices, 5 Mead. Massachusetts, 596. Poland v. Lano Isle Valley R. Co. 52 VT 144, 177. From the employment of capital or otherwise, the expression used is net income or net annual income. 10. And especially the phrase whole income means the aggregate of all receipts without any deduction for expenses or losses, that is, it means gross receipts and not net profits. 11. But, as stated in an earlier section 12, if this word is associated with the term profits, as in the phrase gains, profits, and income, it may take color from the more restricted term and be limited by it. That is to say, in the phrase quoted, the word income should not be taken in its most extensive signification, but as meaning income which is in the nature of a profit, in other words, net income. But it must be admitted that there is some authority to the contrary. 13. Unless limited by the context, however, the word income is one of very broad and comprehensive meaning. Thus, in a constitutional provision that no municipal corporation shall become indebted in any 1 year for a greater amount than its income, unless with the consent of 2/3 of the voters, the word income means income derived from any and all sources, and not that derived from taxation alone. 14. But it cannot be too strongly insisted upon that the word income, when properly used, is applicable only to receipts in cash. When a bond which was purchased at a discount reaches par in the market, the owner cannot properly be said to have made 10 people v. Supervisors of New York, 18 Wend. N.Y. v. Shook, Fed. Gas. No. 17,406. 11 Lawless v. Sullivan, 3 Can.
Okay, hold on. So, unless limited by the context, however, the word income is one of very broad and comprehensive meaning. Thus, in a constitutional provisions that no municipal corporation shall become indebted in any one year for a greater amount than its income. Okay, but it cannot be too strongly insisted upon the word income when properly used is applicable only to receipts in cash. Huh. Am I reading this right? So are you saying that only things done in cash are taxable? Huh. Interesting. I mean, don't I'm not saying that's your argument all day because you'd still have to go through these court cases and find here where they ruled on that. I'm sure it's only a piece, but interesting nonetheless. Let's keep going.
100. A profit, he is in a position where he can realize a profit if he sells the bond, but not otherwise. If he sells, then the sum gained may constitute a part of his income, but it cannot be so described while he continues to hold the security. So, the farmer's crop is not his income, it is the source from which his income will be derived when it is converted into cash. So, a sum which is due as interest on a note, but which remains uncollected at the end of the year, may be reckoned as a part of the year's income, as a matter of bookkeeping, but it is not properly described as income until it is received, that is, it is income when it comes in, but not while it remains outstanding. This rule may perhaps be relaxed so far as to admit an exception in the case of certain items which are received as the equivalent of money and which are readily convertible into cash. But the principle is, as ruled in an English case, that nothing is to be considered as income except what represents value in money, that is, either money or something that is equivalent to money because it can be converted into money and the proceeds expended in any way the recipient may please. In this case, speaking of the income tax of that country, it was said, it is a tax on income in the proper sense of the word. It is a tax on what comes in, on actual receipts, not on what saves his pocket, but on what goes into his pocket. 15. Of course it is entirely within the power of a legislature having jurisdiction to lay an income tax to make the word income include items which are not at all proper to be described under that name. But then those items are taxed, not because they constitute income, but because the legislature has said that they shall be taxed. And on the other hand, when the word income is clearly defined in the act imposing the tax, it cannot be taken to include anything which is not within that definition. Point 16 is Tenant v. Smith 1892 App. Ca. 150, 61 Law Jure. PC. 11. Is City of New Orleans v. Hart, 14 Law. N. 803, City of New Orleans v. Fassman, 14 Law. N. 865. We conclude therefore that, for the purpose of an income tax, a proper definition of the word income would be all that a man receives in cash during the year, except such sums as are merely capital or principal in a changed form, that is, excluding sums which are merely the proceeds of some other form of capital converted into cash. 33. Profits and gains compared and distinguished. Profit is the gain made on any business or investment when both the receipts and expenditures are taken into consideration. 17. It is the amount of acquisition beyond expenditure, the excess of value received for producing or selling over and above cost. 18. It represents the net gain made from an investment, or from the prosecution of any business, after the payment of all expenses incurred. Point 19. In the common acceptation of the term, profit is the benefit or advantage remaining after all costs, charges, and expenses have been deducted, because until then, and while anything remains uncertain, it is impossible to say whether or not there has been a profit. 20 or, according to a fuller description given by the Supreme Court of California, the word profits signifies an excess of the value of returns over the value of advances, the excess of receipts over expenditures, that is, net earnings. Income. Merced means the advance in the price of goods sold beyond the cost of purchase. In distinction from the people v. Merced means the advance in the price of goods.
Okay, but once again, what does it say here? It says in commerce. When you're working at your job, you're not in commerce. The company's in commerce. You're not in commerce. You're a laborer. You're getting things prepared for the business who does it. When that business sells those things, you don't get any of that money. When the business sells those shoes or those records or the car or whatever else, they're not giving you credit. You're behind the scenes. You see what I'm saying?
Sold beyond the cost of purchase. In distinction from the wages of labor, it is well understood to imply the net return to the capital or stock.
Did you hear that? It says in distinction, meaning different from the wages of labor. And I know they kind of threw around these words and whatever, labor, and I might say compensation, whatever. What I'm trying to say is that you are generating private compensation. Your labor, the courts have already ruled labor cannot be taxed. It's not taxable, but you can make an election to be taxed, which is why you're getting taxed. Now, if you're a police officer or a lawyer or a postal worker, etc., public person, then yes, you have to be. You're getting wages. You have income. CDL, you have income. Police officer in your cruiser, you have income. You are literally using your car on the streets to generate income for your entity. Your paycheck comes from the state or from the Fed or a combination thereof, and that is derived from there. You are taxable, not people at regular jobs. Now, your benefits and privileges, like your 401k or your stocks, yeah, things like that, those are products of the system. Those are taxable. They made those. They created those. Those are the belly of the beast. It's literally touching the wall.
What? 20 only the wages of those employed by the capitalist, but the wages of the capitalist himself for superintending the employment of his capital stock. Profits are divided by writers on political economy into gross and net, the former being the entire difference between the value of advances and the value of returns, and the latter so much of this difference as arises exclusively from the capital employed. Profits cannot consist of earnings never yet received. 21 So, the term profits as used in a statute imposing a tax of 5% on all profits of railroad and canal companies, refers to the profits arising from the operation of the railroad or canal, but without deduction of interest paid to its bondholders or dividends paid to its stockholders, that is, the excess of receipts over expenses of operation. 22 But the surplus earnings of a corporation over and above all expenses are taxable as profits, notwithstanding that it is required by law to appropriate all such surplus to a particular purpose, as, to a sinking fund, and to no other. 23 It is said, and with truth, that this term is often used as synonymous with income and as meaning the same thing, and particularly where the two words are coupled in the same phrase. 24 And one court has remarked that, when they are thus joined together, there is no difference in the meaning of the words, and the use of them both is only due to a lawyer-like fondness for using several words where one would be sufficient. 25 But this is scarcely correct. There is a substantial difference in the meaning of the two words. And it is more accurate to say that, when they are joined together in the same phrase, the word profits is used to particularize. And 21 People v. San Francisco Save. Union, 72 Cal. 199, 13 Poc. 498. 22 Sioux City and P. Arco. 20. Point out one kind of income, or income derived from a particular source, and it will generally be found that their joinder is easily explained from their correlation with other descriptive words in the same sentence, as, for example, where gains may be correlated with sales or dealings in property, in come with such words as salaries and earnings from professions and vocations, and profits with business, trade, and commerce. Besides, income is clearly a word of larger import than profits. The former term may very properly include such items as the rent of houses, interest on investments, the earnings of a professional man, or the salary of an officer of a corporation, but none of these could with any propriety be called profits. In effect, the latter term is more appropriately confined to gains resulting from the operations of trade or commerce, and especially from mercantile or manufacturing business or transportation. Moreover, it is important not to lose sight of the distinction that, while income means that which comes in or is received from any business or investment of capital, without reference to the outgoing expenditures, profit means the gain which is made upon any business or investment.
Did you hear that? It says income means that which comes in or is received from any business or investment of capital. Hot damn. Gina? Damn it, Jackie. I've been telling you, they're doing it's business. Only businesses are supposed to be taxed. You as a national with your social security number are not a business. But you can use that name and that social as a business because you have the ability to say which one it is. You have the legal right to depict yourself or allow yourself to be depicted as a business. Essentially, it's a trust, right? But that trust can be operated as a business. You can use it either way because you're both. You are both. You have both. You can use it in either way. We've been using it wrong. It says income means that which is in or received from any business or investment of capital. That is not what you're doing at your job. But when you invest your money into a business or a investment like bonds and stocks, that then becomes taxable. That's why those things are actually taxable, not you. All right, let's keep going. Roll them.
When both receipts and payments are taken into account. Point 26. It is not quite so easy to account for the use of the word gain in conjunction with the two other terms which we have been considering. But it may probably be said that when a tax law employs the phrase gains, profits, and income, to describe what is taxable, the term gains is inserted out of abundant caution, and intended to include an acquisition of the taxpayer which is not to be described as a profit, and which might not be included in the term income if that word were taken in a narrow sense. Properly speaking, gain means that which is acquired or comes as a benefit. 27 and in a 26 in Re Murphy, 80 App. Div. 238, 80 N. T Sup. 530. 27 Thorn v. Debretuil, 86 App. Div. 405, 83 N. Statute laying an income tax. It may mean money received within the year which is not the fruit of a business transaction nor of the labor or exertion of the individual, but something arising from fortuitous circumstances or conditions which he does not control. In this signification, the term would include money received as a legacy or money won on a wager. 34. Change or substitution of capital. Distinguished both in popular and legal parlance, Income is distinguished from capital or principal. Capital is the source of income. Income is the fruit of capital. Capital may be made very mobile and constantly changed from one form of investment to another. Each time that it returns to the owner, it may or may not bring income with it. But it would be a misnomer to reckon the whole of each such return as income simply because it is so much money coming into the possession of the owner out of the funds so returning. There must first be deducted, in case there has been no loss, a sum sufficient to replace the capital originally invested, and the balance, if any, will be income. Thus, when money is loaned on a promissory note for 1 year at interest, and the note is paid at maturity with the accumulated interest, the sum received must be apportioned between capital and interest. The receipt of so much of that sum as equals the face of the note is not a receipt of income, it is a replacement or substitution of capital. Only the money received as interest constitutes income. So the income of a merchant does not include his gross receipts, but only so much thereof as represents the profits on his sales. The remainder is capital replaced. Again, a sum of money received from a railroad company in payment of damages for a part of a person's land taken by the railroad for its use, is not income, it is a substituted capital. 28 And the mere change or transfer of 28 Gibson v. Cook, 1 Mead, Massachusetts, 75. BL. Inc. Tax 6, 81. A fund held in trust, from the hands of one trustee into the hands of another or substituted trustee, does not make the whole fund in the hands of the last trustee gains, profits, and income. Within the meaning of the income tax law. 29 It is of course possible that the word income may be so stretched as to include even capital returned, if the context absolutely requires such a construction. In one case, on the construction of a statute authorizing certain commissioners to deposit the income of a certain fund, it was held that the word had the same meaning as money or receipts, and that it was to be interpreted as embracing all receipts of money, whether of principal or interest, from the mortgages or other securities in which the fund had been previously invested. 30 But this construction was reached by reading the statute with reference to certain other statutes relating to the same subject matter, and no such necessity would ordinarily apply in the interpretation of income tax laws, where, on the contrary, the rule of strict construction in favor of the taxpayer would require a careful distinction to be observed between capital and income. 35. Rent of land and royalties. Rent paid by a tenant for the use and occupation of real estate, is always considered as income of the lessor. 31 And this has been specified as one of the varieties of taxable income in practically all of the income tax laws which have hitherto been enacted. It should be noted, however, that the Statute of Virginia accepts ground rents or rents charge, which is entirely proper, since the annual payments under a ground lease are not so much to be regarded as rent, or a price paid for the use of the land, as in the nature 20. Of periodical installments of purchase money. In a will or a deed, the expression yearly income of real estate may mean the balance of what is received in the way of rent, after deducting taxes paid. 32 And the same result is effected under the income tax laws by the provisions allowing a deduction from the total income of taxes paid within the year, and also an allowance either for depreciation of the property from which income is derived or for its reasonable repair. Where farming land is leased to be worked by a tenant on shares, the income which the lessor derives from it is his share or proportion of the produce, or rather, the sum which he realizes from the sale of his part of the produce. 33 It is also held that rent reserved in a lease of land containing coal or other minerals, the mines to be worked by the lessee, is income of the lessor, although it is stipulated to be paid in the form of a royalty of so much for each ton of coal or other mineral extracted. 84 But this may depend on the intention of the parties as to making a lease proper or a sale, and this in turn may be presumed from the form of the contract which they make. For if the transaction takes the form of a sale of the coal, or other mineral, in place, the proceeds received will be a part of the corpus of the estate, that is, capital or principal, but not income. 35 Thus, a demise of all the coal under the surface of a specified piece of land is a sale of the coal, not a lease, and the sums due and paid by the lessee to the lessor as royalties are not rents, and therefore not income, but purchase money of real estate. 8632 Inhabitants of Freeport v. Inhabitants of Sydney, 21 Me. 305. S.S. Thompson's Appeal, 100 Pa. St. 478 S** Ely's Appeal, 103 Pa. St. 300, Reynolds v. Hanna, 55 Fed. 783, 797, Wentz's Appeal, 106 Pa. St. 301, Bedford's Appeal, 126 Pa. St. 117, 17 ATL. 538, Shoemaker's Appeal, 106 Pa. St. 392, McClintock v. Dana, 106 Pa. St. 386, Hill v. Gregory 1912 2K. B 61. 30, 36. Rental value of residence. The Wisconsin Income Tax Law of 1911 provides that the term income shall include the estimated rental value of residence property occupied by the owner thereof, and hence the taxpayer who owns the house in which he lives must include in his return of his income the annual rent which he could or would receive for the property if he chose to let it and reside elsewhere. This provision is in accord with the principles of income taxation in England and some other foreign countries, but was not known in American legislation until introduced by the Wisconsin statute. Indeed, the rental value of the taxpayer's residence, when owned by him, was expressly directed to be excluded from the computation of his income by the Acts of Congress of 1864 and 1870. The validity of this clause in the Wisconsin law was assailed on the ground that, as such rental value is not income in any proper sense of the word, it could not be made income by the mere declaration of the legislature that it should be such. But the Supreme Court of the state saw nothing in this provision to invalidate the statute. It is said, observed the court, that this is not income, and that calling it income does not make it income. It may be conceded that things which are not in fact income cannot be made such by mere legislative fiat, yet it must also be conceded, we think, that income in its general sense need not necessarily be money. Clearly it must be money or that which is convertible into money. 87 But this is by no means a satisfactory way of meeting the objection. The court would have taken up much stronger ground if it had ruled that the rental value of an owner's residence is not income at all, but yet that it is subject to the tax because it is so declared in the statute and because it is a thing of value which the legislature has the power and authority to tax, whether or not it constitutes 37 State v. Frere, 148 WIS. 456, 134 N. W 673, 26 AM. And N. N. Gas. 1147. Income. On economic grounds such a provision is more easily defensible. And on this point the court in Wisconsin, in the same connection, remarked, the clause was doubtless inserted in an effort to equalize the situation of two men each possessed of a house of equal rental value, one of whom rents his house to a tenant, while the other occupies his house himself. Under the clause in question, the two men with like property are placed upon an equal footing, and in no other way apparently can that be done. 38 It is true the English and Scotch courts hold that the annual rental value of a house which a man owns and in which he lives, and which he could rent to another if he chose, is a part of his income for purposes of taxation. 39 But it is otherwise if the house is provided for him by others, to be occupied during his life, but without any power or authority on his part to let it to another. 40 And the advantage gained, or the saving effected, by having the right to occupy another person's house as a residence free of rent, as in the case of a manager of a bank who has the right, so long as he continues in his office, to reside in the building owned by the bank and used for its banking purposes, is not income in such sense as to be taxable. 41 Under the income tax laws elsewhere than in Wisconsin, it is thought that this item could not be brought within the definition of income by any reasonable or permissible construction. Thus, it has been held, though not in connection with the subject of taxation, that neither the increased value which would accrue to lands of a charitable institution if they were used for other purposes than the charity, nor their use for the purposes of the charity without realizing an actual income, can be regarded as annual income within SS State v. Freyer, Supra. 39 Cork v. Fry, 32 Scotch Law Rep. 341. The meaning of a restriction in the charter of such an institution upon holding property which shall exceed a specified annual income. Annual income, it was said, means annual receipts, and is not the equivalent of annual value. And even if the value of the use could be regarded as annual income, it should be computed, not with reference to the market value, but to the annual value to the corporation for the special purpose to which the property was devoted. 4237. Salaries and earnings from professions and trades. A salary accruing to the taxpayer, whether payable annually or at shorter intervals, is taxable as a part of his income, and it is immaterial, except in so far as the statute makes express exceptions, whether he earns it in the capacity of a public officer or as an employee of a private corporation, or a partnership, or an individual. 43 Thus, the pay of an army officer on the retired list is income and taxable as such. 44 Nor does it make any difference that the amount of the salary is uncertain or varies from time to time, or that it depends on the extent of services actually rendered or the amount of business transacted, or that it may include commissions on sales. Whatever is received in the course of the year in the way of salary, wages, or compensation constitutes a part of that year's income. Thus, it is said in an English case that income includes all gains and profits derived from personal exertions, whether such gains and profits are fixed or fluctuating, certain or precarious, and whatever may be the principle or basis of calculation. Hence a locomotive engineer, who earns more than the statutory minimum, is taxable, although he is not paid a salary but so much for every mile he runs his engine. 4542 Betts v. Betts, 4 ABB. New Gas. NY. 317. 43 White v. Kohler, N. J. 57 ATL. 124 in Reward 1897 1Q. B 266. 45 Attorney General v. Ostrom 1904 App. Gas. 144. So also the earnings of professional men, such as lawyers, physicians, surgeons, clergymen, engineers, architects, authors, and others, derived from their professional employment, constitute taxable income, if sufficient in amount to come within the terms of the statute, even though not specifically mentioned in it. And it is immaterial by what name such earnings may be called, or whether they take the form of a fixed periodical compensation or accrue in each instance in consideration of particular.
All right, you guys hear that? So also the earnings of professional men. I mean, technically, I guess, you could say that that leaves out women, right? I mean, women shouldn't be taxed. No, just kidding. It's an old book, so that's how they talk, whatever, blah blah blah. Um, but because technically they could say, well, men, and then the category that also has the word men in it is the woe men. So woe men are a type of men. So you're not out of it either. But it says so. Earnings of professional men such as lawyers, physicians, surgeons, clergy, engineers, architect, authors. Damn, authors too. That's messed up. and others derived from their professional employment. I didn't know that authors were professional employment. Constitute taxable income. Are you seeing this? Are you hearing me? Do you feel me? Baby. Yay, yay. So once again, I was telling you now, and it says others. Now, of course, the others would be the people like, police officers, postal, because those are all considered professional. Those are considered in the public. Okay, so once again, this book, this treatise, is proving me right. Bam! Your boy knows his stuff. Come on now. This is child's play. Remember my first beer? Let's go.
Services rendered. And the same is true of the wages or earnings of mechanics and artisans, if sufficient in annual amount to come within the purview of the statute, as may easily be the case under some of the state laws. And in all ordinary cases, whatever accrues to the taxpayer as compensation for his personal exertion or endeavor will be taxable as income, no matter what may be the nature of the employment or pursuit which he follows, since the terms of the statutes are broad enough to cover almost every conceivable kind of activity. In an English case it was held that betting on horse races, when carried on systematically and annually and as the person's chief or only way of gaining money, is a vocation within the income tax law, and he must pay the tax on his winnings, if any point.
Now, why would he have to do that? Because he's investing, okay, into something. He's not trading his time and labor for compensation. He's taking part in an activity where he's putting money on something that is a bet, and that bet is a product that is for the public, person, officer. They made the horse track to be commercial. He's investing in the possibility to make money off of this event, just like stocks and bonds in your 401k. You get it now.
4638. Pensions, gifts, prizes, and awards. Under the English law it is held that the pension of a retired judge or other public officer, though voted annually by the legislative authority, is taxable as income. 47. But a pension not granted by the government, but by a private individ, UAL or society, as a purely voluntary gift, and without any legal claim upon the donor, in recognition of meritorious past services or for other such reasons, is not a profit or gain arising from any kind of property or from any profession, trade, employment, or vocation, and is therefore not. 46. Partridge v. Mollandane, L. R18Q. 4 ex part Huggins, assessable as income of the recipient. 48. On the other hand, it was held that, where a corporation establishes a pension or benefit fund for its employees, requiring each of them to become a subscriber and to contribute a certain percentage of his salary, but contributions are returnable, except where forfeited.
Okay, so if the corporation calls you an employee, they're then basically stating that you are an extension of the corporation. Now, this is true and it's false. It's technically true because if you fill out a W-4, you're saying I am an extension. If you do a 1099, you're saying I'm not an extension, I'm private, but I'll work here. Don't tax me, I'll deal with that stuff, which is to be not taxed. When we don't argue that we are an extension of the company, because the company is taxable, it's a non-living thing, it's a legal person. It is taxable. It was created inside of their jurisdiction as a juridical legal person, that which has the form of a man but different rights and privileges. You're saying you're an extension of it. So you should be taxed. You're essentially saying, I am a public part of this thing, but you're actually not. You're just allowing them to misname you. But you also then applied and said, well, yeah, I want to fill out the W-4s. You shouldn't have been doing that. But because you're making an election and you have no obligation to do such, and this was done under a level of fraud, misadventure, you're benefiting by getting the benefits of the company and then yet exclaiming you're private. This is not illegal, but it's also gray area. There's no law written. Now, if I was a lawmaker, I would say, well, look, we need to clarify this a little bit more. If you say that you're an employee, but see, here's the problem. Most of these companies won't let you be anything other than a W-2 when you should be a 1099. They're forcing you to do that. That too is gray area. You should be able to work for the company in the position that you want, but we also don't know all of our options. So because of that, and because there is no law against it, you can basically operate at that company as an employee, take the benefits, and still yet be tax exempt because you are in fact both. Now, really, you should only be one or the other. But there's no law that slices cleanly through here because they could argue and say, well, yeah, but you're saying that you're this tax exempt national. It's like cutting a puzzle piece when the puzzle wasn't a puzzle, it was just a picture, and then now you're cutting it up into puzzle pieces. You're cutting along the picture as closely as you can. You're making new pieces. But once again, by identifying as an employee, you're saying I'm an extension of the company. I should be taxed. But you're then saying, but for my compensation, even though I'm generating it as an employee, you're saying I'm gifting it privately to my living version of myself, which is the national. So essentially, you're making it as a citizen, employee, public side taxable, but it doesn't become taxable until it hits that which is going to receive it. And you're now saying that you're gifting it to the beneficiary, which is you in the living human being natural form, and it's tax exempt. You have the right to do this.
For fraud or dishonesty, either by way of a superannuation benefit, or in a lump sum with interest in case of death or retirement, the full salaries of the employees accrue to them and are assessable for the income tax, and not merely the amount received after deducting such contributions. 49 On similar principles, it is held that a gift of money, raised by voluntary subscriptions, and made annually to a minister of religion by his congregation, is assessable as income, because made to him as a minister and in respect to the discharge of his duties in that office, which is an employment within the meaning of the statute. 50 But where a curate receives from a religious society a grant in money, renewable annually at discretion and on certain conditions, and the grant is in recognition of faithful services as a clergyman, but not in respect of the particular curacy which he holds, it is held that it is not taxable as income. 51 So where a portion of a collection made in church was given by way of an Easter offering to the incumbent of the parish by reason of his office, but the gift would not have been made had not the recipient, besides being the incumbent, also been poor. It was held that the money was not given as an additional remuneration for services, but on account of personal poverty, and was therefore not taxable. 52 Similar questions may arise in the administration of the income tax laws of this country. Suppose, for example, that 48 Turner v. Cookson, L. R 22Q. BDIV. 150. 4 Hudson v. Gribble 1903 £1. B 517, 4 Tax Co. 522 Coin re Strong, 15 Scotch Law Rep. 704, 1 Tax Co. 207 by Turner v. Cookson, L. R 22Q. BDIV. 150. 52 Turton v. Cooper, 5 Tax Co. 138 but C Cooper v. Blackiston 1909 App. Co. 104, 5 Tax Co. 347. One receives a gift of money from a relative, or draws a prize in a lottery or in any form of competition, or wins a bet on a race or at the gaming table, or, to take a worthier illustration, receives an award in money, not as payment for services but in recognition of meritorious conduct or achievement or discovery such as the Nobel Prize. It is clear that he makes a gain, though not a profit, and that the sum received is income as distinguished from principal or capital. The federal income tax law includes the income from, but not the value of, property acquired by gift, bequest, devise, or descent. But aside from this specific exception, and as the problem might arise under other taxing laws, the question whether an acquisition of the kind supposed would be taxable as income must depend upon the construction of the statutes. They contain terms broad enough to cover all such cases, as, where the Act of Congress in force declares that the tax shall be laid on the entire net income received from all sources, and upon gains or profits and income derived from any source whatever, and the Wisconsin statute, after enumerat ing certain items, taxes all other income of any kind derived from any source whatever. If these expressions are to be construed as effective to the full extent of the language employed, they would undoubtedly include gifts, winnings, and pecuniary awards or prizes. But if, following the usual rule of statutory construction, the generality of these expressions is to be restricted by a comparison with the more specific terms used in the context, then they would include only gains or income from sources similar to, or comparable with, those already enumerated, such as salaries, professional earnings, mercantile business, invested capital, and so on. In this case, following the analogy of the English cases above cited, it seems that such acquisitions as those we have instanced would not be regarded as income. The same remarks may apply to a judgment for money, the account of which is paid to the creditor within the taxing year. If the cause of action were an injury to property or contract rights, it might be considered as, in some sense at least, a replacement of capital. If it were for services rendered, the amount of the judgment would clearly be compensation, or even salary or fees, though recovered by suit. But a judgment in an action of tort, as, for example, defamation of character or negligence causing personal injuries, would never be regarded as a part of one's income in the common acceptation of the term, and should not be brought within even the most extensive terms of the statute, since a broad and liberal construction in favor of the government is not the rule in such cases, but the reverse. 39. Legacies and inheritances. The Income Tax Act of Congress of 1913 expressly excludes from the taxpayer's income the value of property acquired by bequest, devise, or descent. The former act, that of 1894, on the other hand, included money and the value of all personal property acquired by gift or inheritance. There was no exception as to legacies or property acquired by descent on which an inheritance tax had already been paid, though probably such inheritance tax itself might be deducted under the description of taxes actually paid. The W.I.S. Consine Statute of 1911 allows a deduction of inheritances, devises, and bequests received during the year upon which an inheritance tax shall have been paid to the state. It appears, therefore, that a resident of Wisconsin receiving a legacy from a non-resident, on which the inheritance tax had been paid in the state of the decedent's domicile, must include the amount thereof in his income for the year. The income tax law of Hawaii includes money and the value of all personal property acquired by gift or inheritance, but with the proviso that there shall not be included in the income of any person or corporation any bequest or inheritance otherwise taxed as such. In jurisdictions where the matter is not thus provided for by statute, the question of taxing legacies or inheritances as income is not free from doubt, and the authorities cast but little light upon it. There is, however, an English case, in which it was ruled that a sum of money acquired as a legacy is not taxable under the denomination of income. It was said by Chief Baron Kelly, it would be something startling, and almost ludicrous, to contend that, when a fortune is left to an individual, if it happen to be in money, the whole fortune is to be taken as a year's income. B.S. This was said arguendo, and is there. For strictly speaking obiter dictum, but the point was well brought out and elaborated, and the quotation clearly expresses the conviction of the court. 40. Products of agriculture or stock raising. The profit derived by a farmer or stock raiser from the sale of the products of the farm or ranch, that is, the amount received on such sales less the cost of production, constitutes income taxable under the statutes now in force. In one state, Virginia, this is specially provided for by the statute, which declares that income shall include.
Okay, hold on. Why is a farmer's private home that he produces, shouldn't say produce, but he naturally these are his man, I was gonna say products, I don't want to say that either. These are his privately generated hay, tobacco, corn, meat, whatever. Why is that considered taxable? He's not a commercial. He's not commerce. So what is it? What's going on here? The farmer absolutely has the right to have his farm and feed his family. However, when he has extra and he sells it, now he could give it away to other people in exchange for services or this, that, or the other. But the moment that he decides to sell it for Federal Reserve notes, cash is king. He has entered the world of commerce. That's how they rope him in. And then they'll say, well, sir, we're going to fine you even more. We're going to threaten your ranch. We're going to threaten your livelihood, your family, essentially, because you're doing these things and you don't even have a business name. So then what does he do? He gets a business name. Now they charge him a tax on everything he does. Do you see the game? That's how they get you. Let's keep going.
The amount of sales of livestock and meat of all kinds, less the value assessed thereon the previous year by the Commissioner of the Revenue, and the amount of sales of wood, butter, cheese, hay, tobacco, grain, and other vegetable and agricultural productions during the preceding year, whether the same was grown during the preceding year or not, less all sums paid for taxes and for labor, fences, fertilizers, clover, and other Seed purchased and used upon the land upon which the vegetable and agricultural productions were grown or produced, and the rent of said land paid by said person, if he be not the owner thereof. Though the other state statutes do Knowles v. McAdam, L. R3X. Div. 23, 1 Tax Co. 161. 54 Acts Virginia 1903, c. 148, p. 155, as amended by Acts 1908, c. 10, p. 20. See the statute in full in the appendix to this volume. Not contain such explicit provisions as these, still their terms are broad enough to include the profits of agriculture and also to allow such offsets as those specified in the Virginia Act, in computing the net return. Thus, the Wisconsin law, after enumerating certain sources of income, lays the tax on all other income of any kind derived from any source whatever, and allows the deduction of the ordinary and necessary expenses actually paid within the year in carrying on the profession, occupation, or business from which the income is derived. 55. As to the federal statutes, the income tax law of 1894 contained a specific provision on this subject, following the example of the income tax laws of the Civil War period. It directed that taxable income should include the amount of sales of livestock, sugar, cotton, wool, butter, cheese, pork, beef, mutton, or other meats, hay, and grain, or other vegetable or other productions, being the growth or produce of the estate of such person, less the amount expended in the purchase or production of said stock or produce, and not including any part thereof consumed directly by the family. 56. The Act of Congress now in force omits these particular provisions and reverts to the use of more general language. But it cannot be doubted that it applies to the subject under consideration, since it declares that the net income of a taxable person shall include gains, profits, and income derived from vocations, businesses, trade, commerce, or sales or dealings in property or the transaction of any lawful business carried on for gain or profit. It is to be noted that so much of the produce of a farm as is directly used and consumed by the farmer and his family is not to be reckoned as a part of his income, even though it SS Wisconsin income tax law.
Ha! Did you hear that? It proved me right. Take that, take that, take that. He has the right to take care of his family and for that not to be considered taxable. But his extra that he's producing, when you start offering to people not your family for cash, you're extra, you're mass producing, mass producing, professional. You're entering into the world of commerce. You're doing business in their area on the public side, and they want their cut because they were the first ones to be here. Well, not technically. I mean, it was Native Americans, but we'll leave that alone. They set up shop and said, "Hey, you can do some things privately, but if you do any of this, because we built our sandbox here first, though we share the area, but if you move like this, we control that." Now, how could the farmer get around that? He would have to set up a church or a operate completely privately. He would essentially have to say that anybody doing business with him is part of his private members association. But here's the problem. If they see you doing that, they're going to test you. So what are they going to do? They're going to send agents to see if you will sell to them. The moment you sell to them, one of their undercover agents, they're going to say, you owe us money. You have been doing public stuff. So everybody would need a membership name, number, or card, or written down, or when you, upon purchasing, you become a member of theirs in the private. That's how they get you. Let's go.
1911, 1087M, 1087M, might have been sold, if not so used, and a profit derived from it. 57 Unsold and consumed in the use by the producer, it cannot possibly be brought within any definition of income, nor even regarded as the source of income. Nor need this rule be affected by the fact that the statute may expressly forbid the deduction of personal, family, or living expenses, as this phrase obviously relates to money expended for such purposes. In the next place, grain, or other crops or livestock remaining in the producer's possession and unsold at the end of the year are not to be reckoned as a part of the year's income. This is to be inferred from the fact that those statutes which have dealt specifically with this matter have not directed that the term income should include the amount of crops raised, etc., or the value of such productions, but only the amount of sales thereof, after making the proper deductions. But, aside from this consideration, the rule is deducible from the general principle that a law taxing income does not apply to anything of value which, if sold, is capable of producing income, but which, remaining unsold, is to be regarded as principal or at most as a source of income. In other connect ions, it is true, the word has sometimes been stretched to this extent. Thus, on the construction of a statute providing that a guardian should improve the estate frugally, and apply the income to the maintenance of the ward, it was held that this use of the word income did not require the guardian to lease the real estate and so derive an income in cash from it, but that he might farm the land himself. 58 So, an early case in Maryland holds that, in a devise of real and personal estate and Negroes in trust, the income to be applied for the benefit of a certain beneficiary, the word in 57 Robertson v. Pratt, 13 Hawaii, 590, People v. Purdy, 58 Hun N. Y, 386, 12 N. Y Sup. 307 58 Remington v. Field, 16 R. I 509, 17 ATL. 551. Come is broad enough to include the increase of the slaves. 59 But the rule of construction in regard to a tax law is not the same as that which applies in the case of a testamentary or other trust. Whatever latitude may be allowed in the latter case, to carry out the purpose of the trust, the rule for a statute imposing taxes is that the construction is strictly in favor of the taxpayer and nothing is included as taxable unless plainly and distinctly made so by the words of the Act. 8041. Produce of mines and oil and gas wells. The owners of mines producing coal, gold, silver, or other minerals, or of nitrate beds or other similar natural deposits, or of oil or natural gas wells, are assessable for the income tax upon the net profits realized by the sale of their products in each year. 61 The argument has sometimes been advanced that, as minerals in place constitute a part of the realty, and as the extraction of any given quantity leaves the investment of the owner worth just so much the less, the sale of mineral products should be regarded as a sale of capital assets, and not as income. Thus, in a case in Pennsylvania, an oil company, having all its capital invested in oil-producing property, and paying dividends entirely out of the products of its oil wells, resisted payment of an income tax assessed against it, claiming that it could have no taxable net income until the proceeds of its business had repaid all the capital invested, since, in view of the depletion of its sources of revenue, its dividends paid included not only earnings but also a portion of its capital returned in this way to the stockholders. But the court re 59 Holmes v. Mitchell, 4 MD. 532. EO Supra, 29. EIC Alianza Co. V. Bell 1906 App. Gas. 18, Rimney Iron Co. v. Fowler 1896 2Q. B. 79, 3 Tax Co. 476, Knowles v. McAdam, L. R3X. DIV. 23, 1 Tax Co. 161. Arizona Copper Co. V. Smiles, 29 Scotch Law Rep. 134, 3 Tax Co. 149, Stevens v. Puert Goldman. Fused to accept this view, holding that all the income received by the company from its works, after deducting the operating expenses, was net income and taxable as such. 62 Moreover, this doctrine is well within the analogy and the reason of the well-known rule that in the case of mining companies, quarry companies, and the like, which have what is called a wasting property, the payment of dividends to the stockholders out of the amount realized on the sale of their products is not regarded as an impairment of capital, nor are such companies required to create a sinking fund, out of earnings, before declaring dividends, to offset the gradual depletion of the property in which the capital is invested. 63 So it has been held that the income of a decedent's estate, as distinguished from the principal, includes the proceeds of the sale of oil produced after the testator's death, accruing as royalty under an oil lease of his lands made by him before his death in consideration of a royalty of part of the oil. 64 Further, the taxability of profits derived from the sale of minerals is recognized in the federal income tax law by the provision allowing a deduction in the case of mines, for depletion of ores and all other natural deposits on the basis of their actual original cost in cash, or the 62 Commonwealth v. Ocean Oil Co., 59 Pa. St. 61 ES People v. Roberts, 156 N. Y 585, Excelsior Water and Mining Co. V. Pears, 90 Cal. 131, 27 Poc. 44, Levy. New Chattel Asphalt Co., L.R. Ion, E** in Re Woodburn's estate, equivalent of cash. Naturally there must also be deducted the cost of production, that is, of mining or extracting the ore, and the taxable net income of the owner will be the price received on the sale of his products less these deductions. But here, as in the case of agricultural products discussed in the preceding section, the measure of taxable net income is not the amount or value of the products of the year's operation, but the net proceeds of sales, and hence there should not be included any ores or other products remaining unsold at the close of the year. And conversely, the year's income is not measured by the year's production. For irrespective of the time when the particular ores were brought to the surface, their proceeds are taxable as income of the year in which they are sold. Nor should the estimate of income be made to include any part of the products of mines or wells which is used by the owner in the heating, lighting, or operation of his own plant, or otherwise consumed in aid of production. There is one decision which apparently contravenes this last statement. Under a state statute imposing a percentage tax on the gross receipts from total production of coal and other minerals, it was held that a railroad company is subject to the tax on coal mined by it on its properties, though the coal is not sold but used in the operation of the road. 05 But the court felt compelled to adopt this conclusion by a consideration of the context and the necessity of bringing the different provisions of the Act into harmony and effective operation. It was said, with respect to the controversy as to the application of the law to coal mined and used by the railway company, no receipts being realized from sales, the rule of construction to be followed is that all the provisions relative to the matter should be harmonized and given effect, if that may be done consistently with the evident legislative intent. The tax purports to be laid upon a percentum of the gross receipts from the total production of coal, and from these words standing alone a meaning might be extracted that S. Missouri, K. and T. Re. Co. V. Meyer, 204 Fed. 140. Only taxation based upon sales was contemplated. But the tax is payable by all persons engaged in the mining or production of coal, etc., and not in selling it. A sworn return is exacted showing the location of the mine or well, the kind, the gross production, actual cash value, and other information, and while the auditor is, under the same section, authorized to ascertain the gross receipts and compute the tax, the next section empowers him to ascertain the amount and value of production, compute the tax, etc. And section 7708, in providing for a rebate of taxes when asphalt, ores, or petroleum, or other minerals, have been manufactured or refined, contemplates a tax irrespective of sale of the natural product and not dependent on the sale after it has been manufactured or refined. The intent, from the several provisions taken together, seems therefore manifest to provide for the collection of a tax, whether the mineral is put on the market or used by the producer, and by the expression gross receipts from total production to refer to equivalence in either case, and accomplish the object of obtaining revenues from all production of mineral, regardless of use. This conclusion appears to be necessary, notwithstanding the conceded principles that taxes must be imposed by law, and that the law should be construed favorably to the taxpayer and not extended by implication beyond its clear intent. 42. Profits of mercantile business. In so far as the income tax falls upon the profits of a merchant, the amount of it is not dependent on or estimated by the amount of his gross sales or gross receipts, but the taxable income is that derived from sales of goods made in excess of their cost, after deducting from the income or profits the expenses and other items allowed by the statute. 68 The deductions ordinarily allowed include interest on borrowed capital, taxes paid, losses incurred which are not compensated by insurance or otherwise, bad debts written off, and depreciation. E. E. Miller v. Douglas, 42 Tex. 288 BL. Inc. Tax. 1, 97. Of property. Besides, the statutes allow a deduction of necessary expenses actually paid in carrying on the business, as in the federal statute, or the ordinary and necessary expenses actually paid within the year in carrying on the business from which the income is derived, as in the Wisconsin statute. These expenses, in the case of ordinary mercantile business, will include such items as the prime cost of goods, salaries and wages of employees, freight, advertising, insurance, and the like. But it must be observed that the income from a mercantile business, under the tax law, is not merely the profit arising from the sale of that particular stock of goods which the merchant had on hand at the beginning of the tax year, but it is the net profit arising from the whole year's commercial dealings in the goods handled by the merchant, no matter how often, in the course of the year, his stock may have been depleted, wholly or in part, and renewed. 6743. Profits from unauthorized business. It is held that where a state tax is laid upon the gross receipts or the net income of corporations, or upon the volume of business transacted by them as measured by such receipts or income, it may include and apply to receipts by the company derived from a business beyond its charter powers or in which it had no authority to engage. 68 And so it was ruled that a corporation cannot escape payment of United States internal revenue taxes on the ground that the business in which it is engaged, or from which its profits or income are derived, is unauthorized by its charter or by the laws of the state, or is otherwise ultra vires. 69 It is undoubtedly proper to apply these rulings to the assessment of federal and state income taxes. It is true the Act of Congress refers to profits. 67 Wilcox v. Middlesex County Com. Rs. 103 Mass. 544 ES People v. Roberts, 32 App. Div. 113, 52 N. Y Sup. 859, affirmed, 157 N. Y 677, 51 N. E 1093. 69, Salt Lake City v. Hollister, 118 U.S. 256, 6 sub. Ct. 1055, 30 L. ed. 176. Derived from the transaction of lawful business. But a business may be nonetheless lawful because it is beyond the limited powers of a particular corporation engaging in it. And it is probable that the word quoted was meant only to exclude those occupations which are forbidden to all persons, as being immoral or contrary to public policy, and the reason for excluding them was the apprehension that taxing them might appear to legalize them. 44. Income from partnership business. The profit accruing from one's share in the business conducted by a partnership is a part of his income. 70. The net earnings of the partnership constitute income of the firm so long as they remain in the possession or to the credit of the firm as such. But when a proportionate part is drawn out and paid over to an individual partner, it becomes and constitutes a part of his private income. And although an interest in the stock in trade of a partnership or in the business which it conducts may represent an investment of capital, and therefore be principal or capital of the partner, it does not follow that his share of the earnings is impressed with the same character. On the contrary, the dividends of a partnership in which a decedent was interested, and which was continued after his death, have been held not to constitute a part of the corpus of his estate, any more than interest on money constitutes a portion of the principal invested, but such dividends are income and go to the life tenant or beneficiary under a trust. 71. It is true, however, that it would be unjust and double taxation to assess a partnership upon its income derived from its business, and then to tax each partner for his share of the profits as constituting his individual income. But this matter has generally been provided for in the statutes. To Henry Rogers, 37 Miscellaneous. Rep. N.Y. 54, 74 N. Y sup. 829, in Res Locum, 169 N. Y 153, 62 N. E 130. The Act of Congress does not tax partnerships at all. The Wisconsin statute taxes partnerships as well as individuals and corporations, but the individual is allowed to deduct from his taxable income dividends or income received from an interest in any firm or co-partnership, the income of which shall have been assessed under the provisions of this Act. If the other existing statutes leave the subject in doubt, still it is thought that no court would sustain the attempt to assess and collect the tax twice upon the same income. As to the undivided earnings of a partnership, it is true, as above stated, that they properly constitute income of the firm but not of the individual partners. Nevertheless, the Act of Congress subjects them to taxation in the names of the partners. The provision is as follows: any persons carrying on business in partnership shall be liable for income tax only in their individual capacity, and the share of the profits of a partnership to which any taxable partner would be entitled if the same were divided, whether divided or otherwise, shall be returned for taxation and the tax paid, under the provisions of this section, and any such firm, when requested by the Commissioner of Internal Revenue, or any district collector, shall forward to him a correct statement of such profits and the names of the individuals who would be entitled to the same, if distributed. 45. Profits on sale of real estate. Where a parcel of real estate is sold for a price above its cost, the difference is not properly income of the vendor. It is more correctly described as an increase of capital assets. But it is certainly a gain or profit, and falls within the meaning of either of those terms as used in the income tax laws. And it has always been the policy of such laws to assess the tax on a profit thus made, though it has been usual to set a limitation upon the time elapsing between the purchase and sale of the property, since land is often held for long periods and the increase in its value, in ordinary cases, may be supposed to have been gradually accruing during the entire time. The Federal Income Tax Law of 1864 provided that net profits realized by sales of real estate purchased within the year for which income is estimated shall be chargeable as income. The Act of 1870 included in the description of tax able income profits realized within the year from sales of real estate purchased within 2 years previous to the year for which income is estimated. The Act of 1894 taxed profits realized within the year from sales of real estate purchased within 2 years previous to the close of the year for which income is estimated. As to the state statutes, that of Wisconsin expressly includes as taxable income all profits derived from the purchase and sale of any property acquired within 3 years previous, and this is construed by the State Tax Commission as referring to capital assets and not to ordinary stocks of merchandise, and therefore it would be applicable to real estate. The Income Tax Law of Hawaii enumerates in the classes of taxable income profits realized within the year from sales of real estate, including leaseholds, purchased within 2 years. The statutes of the other states contain no specific provision as to the profits on sales of land, but their general terms are broad enough to include this case. The Act of Congress of 1913 contains the following very ambiguous clause: the net income of a taxable person shall include gains, profits, and income derived from **** sales or dealings in property, whether real or personal, growing out of the ownership or use of or interest in real or personal property. As to the latter part of this sentence, though it is difficult to discern any precise meaning in it, one may hazard the guess that it was intended to apply to the purchase and sale of leaseholds, life estates, undivided joint interests, and other estates less than a fee. Another possible construction might be suggested, and one which would give meaning and effect to the whole sentence. This might be accomplished by reading the word or into the clause between the words personal and growing, as having been inadvertently omitted, and by a slight transposition of some of the other terms. The sentence would then read, the net income of a taxable person shall include gains, profits, and income derived from **** sales or dealings in property, whether real or personal, or growing out of the ownership or use of real or personal property or an interest therein. As thus reconstructed, the provision would lay the tax on what is called the unearned increment of land, that is, an increase in its market value, accruing within the year from any other cause than its improvement by the owner, or the corresponding profit or advantage to the owner, in view of the fact that he could now command a higher price for it than formerly, although he does not actually realize his profit by selling the property, but continues to hold it. But since this would greatly enlarge the scope of the statute, and subject to taxation various items which would be exempt under any other interpretation, it is doubtful whether the courts would feel justified in taking this course with it. The term dealings has a definite meaning in law. It is equivalent to traffic. It does not apply to the operations of one who buys to keep, though he may afterwards sell, but to the buying of any kind of property or commodity for the purpose of selling again at a profit, and that, not merely on a single occasion, but as an occupation or pursuit, or in other words, dealing in any article is making successive purchases and sales of it as a business. 72 It appears therefore that where one purchases a piece of real estate for residence purposes or as an investment, and sells it for a higher price than he paid, the profit must be included in his taxable income for that. 72 See Clifford v. State, 29 WIS. 327, Saunders v. Russell, 10 Lee, Term. 293, Bates v. Bank of Alabama, 2 Ala. 451, Buckley v. Briggs, 30 Mo. 452, Norris v. Commonwealth, 27 Pa. St 494, Overall v. Bezzo, 37 Mich. 506, State v. Barnes, 126 N. C 1063, 35 S. E605, Vernon v. Manhattan Co., 17 Wend. NY. 524, Goodwin v. Clark, 65 Me. 280. Year. It might be argued that the word sales should take color from the word dealings with which it is associated. But it seems more probable that the legislative intention was to tax not only profits arising from dealing in real estate as a business, but also the profit accruing on single or isolated sales, not frequent enough to constitute dealing in it, and that the words were placed in juxtaposition to mark this distinction. The term dealings may be applied to one who buys and sells land as a speculation, or who buys vacant land and builds houses on it for the purpose of selling the property as so improved, or buys, opens up, and sells suburban property, or otherwise derives his income or a considerable part of it from traffic in real estate. The construction which the English courts have put upon the income tax law of that country excludes the profit arising from a single sale of land, while including profits derived from buying and selling realty as a business. In a leading case, it appeared that a company was formed to buy land in the Malay Peninsula and there plant and cultivate rubber trees. It bought 2 estates and planted a considerable acreage, but did not produce or sell any rubber. Then, its capital being exhausted, it sold the entire property to another company for a price exceeding the amount of capital expended. It was held that the profit arising from the sale was an appreciation of capital, and not taxable as income. In delivering judgment, Lord Salvesen said, "I am unable to distinguish the position of the appellants from that of a person who acquires a property by way of investment and who realizes it afterwards at a profit. It is well settled that in such a case the profit is not part of the person's annual income liable to be assessed for income tax, but results from an appreciation of his capital. No doubt if it is a part of his business to deal in lands or investments, any profits which in the course of that business he realizes form part of his income, but the mere fact that a poor son or company has invested funds in the purchase of an estate which has subsequently appreciated, and so has realized a profit on his purchase, does not make that profit liable to assessment." 7346. Profits on sales of securities in the general law, apart from matters of taxation, in addition to one's wealth obtained by selling stocks, bonds, or any other form of securities or investments at a price above their cost, is not income but an appreciation of capital. Nor is it profit in the ordinary or commercial sense. Profit is the acquisition of gain above expenditures arising from some transaction or operation, and does not include premiums received on the sale of securities. 74. A similar rule prevails in the law of trusts and of wills. Thus, where a trustee invests money of the trust estate in bonds, and subsequently sells the bonds at an advance, and invests the proceeds in other securities, the profit on the bonds is part of the principal of the estate, and not income, as between the life tenant and the remainderman. 75. So the words dividends and income in a will devising property in trust, the dividends and income thereof to be paid to the testator's daughter, with remainder over after her death, do not include the increase in the value of the corpus of the estate caused by the investment of the funds and stocks and their sale and investment in other stocks at a profit. 76. But it seems that the profits and income of an estate devised in trust for a named beneficiary will include the profits made on land purchased by the executor at a foreclosure sale of a mortgage to secure a loan of the funds of the estate. 77. 73. To Brow Rubber Syndicate v. Farmer, 5 Tax Co. 658 I** v. Long Island Loan and Trust Co., 75 Hun, N. T. 533, 27 N. Weisup. 400. To Enrique, St. In the English law of taxation, a profit realized from the sale of securities is not reckoned as income, except in cases where the person pursues the buying and selling of securities as a business or occupation. It is quite a well-settled principle in dealing with questions of assessment of income tax, that where the owner of an ordinary investment chooses to realize it, and obtains a greater price for it than he originally obtained it at, the enhanced price is not profit in the sense of the income tax law. But it is equally well settled that enhanced values obtained from realization or conversion of securities may be so assessable, where what is done is not merely a realization or change of investment, but an act done in what is truly the carrying on, or carrying out, of a business. The simplest case is that of a person or association of persons buying and selling lands or securities speculatively, in order to make gain, dealing in such investments as a business, and thereby seeking to make profits. There are many companies which in their very inception are formed for such a purpose, and in these cases it is not doubtful that, where they make a gain by a realization, the gain they make is liable to be assessed for income tax. What is the line that separates the two classes of cases may be difficult to define, and each case must be considered according to its facts, the question to be determined being, is the sum of gain that has been made a mere enhancement of value by realizing a security, or is it a gain made in the operation of business in carrying out a scheme for profit making? 78. So where a person buys a doubtful debt and recovers a larger sum than he paid for it, the gain is not profit in the sense of the income tax law, unless the purchaser is making a trade of buying such debts. 79. But on the other hand, where a company is empowered by its charter to vary its investments, and Gen 78 California Ornean Copper Syndicate v. Harris, 6 Fraser. 894, 5 Tax Co. 159, Tobrow Rubber Syndicate v. Farmer, 5 Tax Co. 658. I Assets Co. v. Inland Revenue 1897 W. N 144. Errolly to sell or exchange any of its assets, the net gain by realizing investments at larger prices than were paid for them constitutes profit chargeable with income tax. 80. In this country, however, under both the federal and state income tax laws, dealing as they do with income or profit from the sale of property, it is difficult to see how the premium obtained on even a single sale of stock, or of a bond or other security, could escape assessment. Under the income tax laws of 1861 to 1870, it was held that a bona fide exchange of stocks for other property, however much to the apparent advantage of the owner of the stocks, was not a sale thereof from which a profit was derived liable to taxation as income, but a transfer of stocks for a promissory note, which is collectible, or an exchange thereof for land, followed by a sale of such land within the year, whether for cash or collect. Ibl promissory notes, was considered as equivalent to a sale of such stock for so much cash. 81. But in view of the limitation of time in those statutes, it was held that the profit made upon bonds bought in 1 year and sold several years later was not to be included in the estimate of the owner's income for the year in which the sale was made. 82. It will be noticed, however, that there is no limitation of time in the present federal income tax law, while that prescribed by the Wisconsin statute is 3 years. 47. Increase in value not realized by sale. In the law of trusts, an increase in the market value of securities of any kind held as investments is not accounted a part of the income of the same, nor is it to
Now, I'm just going to jump out there and say this. I don't know what it is about Wisconsin, but apparently these are some anal ass individuals. All I keep hearing is Wisconsin law, Wisconsin tax, income, Wisconsin, blah, blah, blah. You would think for mostly, well, it used to be mostly farmers, these people would be cool, but apparently, well, I don't know. It's like apparently there's a lot of fighting going on with all that. I don't even know. I don't even know what to say. Just damn. Carry on.
be added to the stated interest which they return in computing the income. Even if the securities are sold, and the increment of value thus converted into money, it is not properly speaking a so Scottish Investment Trust Co. v. Forbes, 31 Scotch Law Rep. 219, 3 Tax Co. 231 SI United States v. Smith, 1 SAI. 277, Fed. Co. No. 16,341. Profit, as we have shown in the preceding section. For an even stronger reason, therefore, it cannot be either a profit or a gain so long as not realized by sale. It is merely an appreciation of capital. The rule, as settled, may be stated to be that an increase from natural causes in the value of real and personal estate held as an investment does not constitute profits, to go to a life tenant, but becomes principal and goes to the remainderman. 83 Thus, a life tenant entitled to the income of a certain legacy, which was invested, was held not entitled to the gain over the original amount invested, arising from an increase in the value of the subject of the investment as it existed in the lifetime of the testator. 84 But a more direct authority for the application of these principles to the subject of income taxation is found in a decision of the United States Supreme Court, construing the Act of Congress of 1864 imposing taxes on gains, profits, and income. It was held that a mere increase in the market value of securities does not come within the definition of any one of those terms, and specifically, that the word gains, as used in the statute, means such gains or profits as may be realized from a business transaction begun and completed during the preceding year. The court said, the mere fact that property has advanced in value between the date of its acquisition and sale does not authorize the imposition of the tax on the amount of the advance. Mere advance in value in no sense constitutes the gains, profits, or income specified by the statute. It constitutes and can be treated merely as increase of capital. 8b Notwithstanding this, the officers of the Treasury Department applied a different construction to the Corporation Excise Tax Law of 1909, which specified, as ss in Revetter, 2 Con. Sir. Ny. 548, 15 N. Y sup. 798 and C in Regary, 103 N. Y 445, 9 N. E 235, Genery v. Olmsted, 36 Hun, N. Y. 536, in Re Proctor, 85 Hun, N. Y. 572, 33 N. Y sup. 196, Lindsley v. Bogart, 87 Hun, X. Y. 137, 33 N. Y sup. 975 S * Thompson's Estate, 11 Pa. Co. Ct. R 198. The measure of taxation, the net income of the corporation, above a certain amount, received from all sources, a narrower expression, it will be noticed, than that of the income tax law. They ruled that a corporation must return, in its estimate of net income, not only profits realized on the sale of real estate during the year, but also an increase in the value of unsold property, if taken up on the books of the corporation, and that any increase in the value of the capital assets, as determined by a physical revaluation, and taken cognizance of by the corporation in book entries, is gain and must be accounted for as income for the year in which such increase is so recognized and recorded. 86 And it must further be remarked that, if the courts should eventually adopt such a construction of the Act of Congress of 1913 as would permit the taxation of the unearned increment of land, as suggested above, supra, 45, it is probable that the same principle would have to be applied to the increase in value of securities, since the statute, at this point, carefully specifies both real and personal property as sources of gains, profits, or income. 48. Uncollected interest and accounts. It is an unsettled question whether a person's income for a given year should be held to include interest on securities accruing within the year but remaining uncollected at its close, and promissory notes and due bills taken in discharge of a pre-existing indebtedness, but not paid within the year in which they are given, and the price of goods sold within the year, evidenced by book entries, but not received in cash. Some of the statutes have expressly included such items, others have not mentioned them. Thus, the Act of Congress of 1864 laid the tax, among other things, on interest received or accrued upon all notes, bonds, and mortgages, or other forms of indebtedness bearing interest, U.S. Treasury Decision No. 1742, pars. 43, 48, and 85. Are paid or not, if good and collectible. And the same language was included in the Act of 1870 and in that of 1894. It will be noticed that this specified only interest, and as to notes and accounts, the courts did not agree. In one case it was held that, within the meaning of the statute, the word income must be taken to mean money, and not the expectation of receiving it or the right to receive it at a future time. And hence it was ruled that the amount of a promissory note taken in 1871 on the sale of a patent right, but not due until 1872, and paid in the latter year, was not taxable as income of the former year. 87. But in another case it was said that promissory notes, book accounts, and the like, due during a given year, may or may not be income of that year. This depends on their value intrinsically or their convertibility into money, property, or available assets. If they have only a nominal, and not a real value or convertible quality, and a man has realized nothing from them, and therefore does not return them as a part of his income, because he honestly believes that they are not real gains or profits, he cannot be convicted of making a false return. 88. And in construing the corporation excise tax law of 19...
Did you guys hear that? If they only have nominal and not a real value or convertible quality, and a man has realized nothing from them, and therefore does not return them as part of his income, because he honestly believes that they are not real gains or profits, he cannot be convicted of making a false return. Let's go.
09, it was held that the word income, as there used, meant that which has come in or which has been already received, and that the net income so taxable should be determined on a cash basis, as distinguished from a revenue basis, and hence, in the case of an insurance company, did not include uncollected and deferred premiums and interest, accrued and due, but not actually received. 89. The federal income tax law of 1913 makes no specific mention of this point, and its intention in regard thereto is not easy to discern. Yet it is a significant fact that, in enumerating the deductions which the taxpayer is allowed to 87 United States v. make from his return of income for taxation, aside from business losses, bad debts, and depreciation of property, only those items are included which represent an outlay in cash, such as interest paid within the year, necessary expenses actually paid, and taxes paid. Hence it may be argued that if Congress did not allow the deduction of items falling due within the year but not actually paid, it would not be equitable to require the taxpayer to include in his income interest and other items accrued and due within the year, though not actually collected. This same argument, as regards the propriety of looking to the one part of the statute to ascertain the meaning of Congress in the other part, was advanced by the court in deciding a leading case under the corporation tax law of 1909. Since that statute allowed as deductions only cash outlays, as expenses actually paid, interest actually paid, and sums paid for taxes, it was argued that it would be strange indeed if, on the opposite side of the account, the company were charged with what it had not received during the current year. 90. And it cannot be denied that it is shocking to the common sense of businessmen to call that income of the year which has not been received or come in, but which has merely fallen due. And so the courts have ruled in several cases. In one, it was held that interest accrued but not payable, and interest accrued but not paid, secured by mortgages drawing interest, are not surplus profits of a corporation. It is not easy to comprehend, said the court, how profits or surplus profits can consist of earnings never yet received. The term imports an excess of receipts over expenditures, and without receipts there cannot properly be said to be profits. Money earned as interest, however well secured, or certain to be eventually paid, cannot, in fact, be distributed as dividends to stockholders and does not constitute surplus profits within the meaning of the statute. 91. In another case, it was held that a tax directed to be levied and collected for and during a certain year on the amount of all interest or coupons paid on the bonds of certain corporations, whenever and wherever the same shall be payable, did not cover interest earned during the year, but payable afterwards. 92. And in a third decision we find the court saying, it seems almost to border upon absurdity to speak of income as including that which has not been received, and which in the ordinary uncertainties of business may never be received. How can it be affirmed of unpaid interest that it will ever be paid, or, if so, when? The same is true of uncollected and deferred premiums. It is manifestly impossible to tell when, if ever, they will be paid. They are neither receipts nor income until paid. 98. Turning to the statutes of the various states, we find that the Wisconsin income tax law does not mention this specific point, but that it lays the tax on income received, and makes the term income include interest derived from money loaned or invested in bonds, mortgages, or other evidences of debt of any kind whatsoever. And the statute of South Carolina contains substantially the same language. Under these laws, it seems a fair inference that there was no intention to tax uncollected interest, since it could not be described as income received. The statute of Virginia is most ambiguous on this point, inasmuch as it professes to tax income in excess of $1,000, whether received or due but not received, within the year, but at the same time makes the term income include interest upon bonds, notes, or other evidences of debt collected or received during the year. I People v. San Francisco Save. Union, 72 Cal. 199, 13 Poc. 2, 4, compared with the contract price, 49. Profit to accrue on uncompleted contracts. In construing the corporation tax law of 1909, which laid a tax measured by the entire net income received from all sources, the officers of the Treasury Department ruled that net income on uncompleted contracts may be estimated on the basis of the percentage of the work completed as compared with the contract price of the whole work. 94. But this ruling is believed to be wholly indefensible. First, because it fails to distinguish between earnings and income. The price to be paid for work done under a contract may be considered to have been earned when the work is completed, and it may be said to have been earned pro tanto as the work progresses. But in neither case can it be described as income until it has been actually paid over and received. That term does not mean the right to receive, or the expectation of receiving, a payment in the future. Secondly, no contractor can be absolutely certain of receiving the price when the work is done. His expectation of so doing may be more or less confident according to the circumstances, but even at the best he cannot be sure that he will not have to reckon with claims for offsets or deductions. And it would seem clear that money which may or may not be paid in the future, and, if paid, may be greater or less in amount, is in no sense income. Further, the ruling in question would be entirely inapplicable to those contracts which involve personal skill, personal confidence, professional services, or the like, where the stipulated compensation is not apportionable. 50. Profits from sale or lease of patent rights. The Commissioner of Internal Revenue ruled, under the Corporation Tax Law of 1909, that receipts from the sale of patent rights are to be included in taxable income, and also that royalties received on patent rights, presumably either on the sale or lease of such rights or on the use of the Patsy Treasury decisions, No. 1742, PAR. 88. Nth article, are also to be reckoned and reported as income, though an allowance would be made for depreciation of patents expiring during the year .96, and the Wisconsin income tax law makes the term income include all royalties derived from the possession or use of franchises or legalized privileges of any kind, which is construed by the Tax Commission of that state as including royalties received from patents. As to royalties on sale or lease, the case is clear, but not so as to receipts from the sale of patents or patent rights. One who buys a patent or rights under a patent, and then sells it at an advanced price, may be said to have made a profit which should be taxable as a part of his income. But where the patentee sells, for example, his rights under the patent in foreign countries, it would rather seem to be a conversion of capital assets into the form of money than the receipt of income. 51. Annuities. The revenue law in Massachusetts provides that personal estate, for the purpose of taxation, shall include the income from an annuity. 9J, and the Act of Congress of 1913 provides that all persons, firms, co-partnerships, companies, corporations, and insurance companies, having the control, receipt, custody, disposal, or payment, directly or indirectly, of annuities or other fixed or determinable annual gains, profits, and income of another person, exceeding the statutory minimum, shall not only make the necessary return thereof, but also deduct and withhold the income tax and pay it over to the United States. From this it may plainly be seen that, at least under the two statutes mentioned, an annuity is regarded and treated as taxable income, whether it be created by grant, by testamentary trust, or by the contract of an insurance company. 5 Treasury decisions, No. 52. Interest on government bonds. The federal statute now in force provides that, in computing the net income of a taxpayer, for the purpose of the income tax, there shall be excluded interest upon the obligations of the United States or its possessions. In former statutes of the same kind, Congress did not hesitate to include the obligations of the federal government. In the Act of 1861, the tax was imposed, among other things, upon interest upon Treasury notes or other securities of the United States. The Act of 1862 taxed interest upon notes, bonds, or other securities of the United States, as did also the Act of 1864 and that of 1870. In the Act of 1894, the provision was that there shall be included all income derived from interest upon notes, bonds, and other securities, except such bonds of the United States the principal and interest of which are by the law of their issuance exempt from all federal taxation. Under the Corporation Excise Tax Law of 1909, it was ruled that interest on United States bonds must be included in estimating the net income of corporations, because this statute imposed a tax, not on the property of the corporation nor directly upon its income, but upon the privilege of carrying on business in a corporate capacity, the net income being used only as a measure of the tax in each particular case. 97. It is not competent for the several states to tax income derived from the bonds or other obligations of the federal government. This limitation might be inferred from general principles of constitutional law. 98. But it is also expressly provided by Act of Congress that all stocks, bonds, treasury notes, and other obligations of the United States shall be exempt from taxation by or under state or municipal or local authority. 99. Some of the states having income tax laws expressly recognize this restriction. Thus, in Wisconsin, the 728 Up. ATT. Gen. 9. Taxpayer is allowed to deduct from his income as returned for taxation interest received from bonds or other securities exempt from taxation under the laws of the United States. 10 degrees in South Carolina, the provision is that, in estimating the gains, profits, and income, there shall not be included interest upon such bonds or securities of the state, or of the United States, the principal and interest of which are, by the law of their issue, exempt from taxation 101 in 2 other states. The law purports on its face specifically to tax income derived from United States bonds. But to that extent, these statutes must necessarily be held invalid in any case in which the attempt was made to enforce such a provision. The states intended are Virginia and Tennessee. In the former, the law provides that income shall include **** interest upon notes, bonds, or other evidences of debt, of whatever description, of the United States or any other state or county. Try. 102 in Tennessee, the statute reads, the amount of income derived from United States bonds, and all other stocks and bonds not taxed ad valorem, shall be taxable at the rate of 5%. 10353. Dividends on corporate stock. Whatever the taxpayer may actually receive from a corporation, by way of dividends on the shares of its stock which he owns, constitutes a part of his income and will be taxable as such. 10** This rule, however, is subject to 2 limitations. First, a dividend, properly so called, is a distribution to stockholders of the whole or a part of the current earnings or profits of the corporation, and not a distribution of capital assets. When a portion of the capital is thus returned to stockholders, it is not income, from their point of view, but a 100 Wisconsin Income Tax Law 1911, 1087 M. 4, E 101 Civ. Code S. Car. 1902, 325. 102 Acts VA. 1908, C. 10, p. 20, 10. 103 Code Tennessee, 690, 710. 104 McGee v. Denton, 5 Blatchf. 130, Fed. Gas. No. 8943. Replacement of capital, except in the few exceptional cases where it is permissible for a corporation to divide current receipts among the stockholders, although the property in which the capital is invested is correspondingly depleted, as in the case of mining and quarry companies and some others. 105 Secondly, where a statute taxing incomes lays its burden upon both individuals and corporations, it is usual to provide that the individual taxpayer may deduct from his return of income for taxation the amount of any dividends received by him from corporations which are subject to the tax, or which have been assessed for the tax or have paid it. This is a just provision, introduced for the purpose of avoiding the double taxation which would result if the corporation were taxed on its profits and the stockholders on the same profits when divided among them. Subject to these provisions, the income tax laws quite commonly enumerate dividends among the specific sources of taxable income. But on general principles of law, and even when not so declared in the tax statute, revenue of this kind is always classed as income. And it is immaterial whether a corporate dividend is declared and paid as a regular dividend. That is, regular in respect either to its periodicity or its amount, or as an extra dividend or a bonus in cash. 108 Thus, where a testator bequeathed to his wife for her life the use, interest, and income of his estate, part of which consisted in stock in an incorporated bank, and the bank afterwards reduced its capital, by returning to the stockholders 1/2 of it with a premium of 40% to be paid out of the surplus, it was held that the word income included the 40% premium returned to the testator's estate, and that it passed under the will to the widow. 107 And the rule is not 105 Supra, 41. And C. Reed v. Head, 6 Allen, Massachusetts, 174, Harvard College v. Amory, 9 Pick. Massachusetts, 446. Lew Lord v. Brooks, 52 N. H. 72. Lore in Re Warren, 2 Con. Sir. NY 411, 11N. Y sup 787. Restricted to dividends declared and paid by corporations truly so-called, but extends also to any distribution of profits among the members of an unincorporated society, syndicate, pool, trust, or other joint enterprise. For instance, where an investment is made in an unincorporated association organized to deal in land as a commodity, and profits are realized from the business, which are divided among the members, with no impairment of the principal, such profits are personalty, representing income, and go to the life tenant under the will of one of the members. 108 And it has been ruled that, when a dividend has been declared and is immediately payable, so that the stockholder can have it on demand, it is to be reckoned as a part of his income for the year, though it has not actually come into his hands as yet in the form of cash. It was said, if the plaintiff's counsel is correct in his position that the profits of an incorporated company, itself an artificial person, are not, in the contemplation of the Act of Congress, a portion of the gains, profits, or income of the stockholders, until they are distributed as dividends, or embraced in a dividend declared by the managers of the corporation, I think it quite clear that, when a dividend has been declared and has become payable, the mere omission of the stockholder to receive or obtain the dividend subject to his call would not excuse him from embracing the amount of such dividend in his statement of his taxable income for the year. 109.54. Same, stock dividends. It is a debatable and unsettled question whether a dividend declared by a corporation, but not payable in cash but in the form of new stock distributable among the present stockholders proportionally, the nominal capital being correspondingly increased, is to be accounted income or capital in the IDS in Re Thompson's estate, 153 Pa. St 333, 26 ATL. 652. 109 McGee v. Denton, 5 Blatch. 130, Fed. Ca. No. 8943. Hands of the stockholder. And this is immediately pertinent to the subject in hand, because if the stockholder receives such a dividend as an accretion to his capital, it is not subject to the income tax, while, on the other hand, if it is income, he should include it in his return, and probably at its market value. Probably it may be stated that the rule as stated by the Court of Appeals of New York is sustained by a majority of the decisions. It is this, where a dividend is declared by a corporation on its capital stock, payable in new stock certificates based on accumulated but undivided profits, it is received as income by the stockholders, and not as capital, since the substance and intent of such a transaction is the distribution of earnings, and it does not result in any actual addition to capital, for although the nominal amount of the corporation's capital stock is thereby increased, yet the corporation actually has neither more property nor more capital. 110 But in Massachusetts and some other states, a contrary rule prevails. 111 In Maryland, the court has ruled that, in determining whether a stock dividend declared on stock constituting the corpus of a trust estate is a part of the corpus, so as to pass to the remainderman, or income available for the life beneficiary, the court is not governed by the form in which the dividend has been declared, but the character of the fund out of which the dividend is paid controls, and where the dividend represents earnings, the dividend is income, while if it is an appropriation of capital, it is a part of the corpus. 112. No Lowry v. Farmers Loan and Trust Co., 172 N. Y 137, 64 N. E 796. And C Solon v. Solon, Wisconsin, 131 N. W 739, Earps Appeal, 28 Pa. St. 306, W. 755. Accumulated earnings or undivided profits of corporations. These are taxable under the Act of Congress of 1913, as income of the stockholder, but only in cases where the taxable income, including such items, is large enough to be subject to the super tax or additional tax, and only in cases where the device of a corporation, accumulating its profits instead of dividing them, is resorted to for the purpose of evading the tax. The provision is that for the purpose of this additional tax, the taxable income of any individual shall embrace the share to which he would be entitled of the gains and profits, if divided or distributed, whether divided or distributed or not, of all corporations, joint stock companies, or corporations however created or organized, formed, or fraudulently availed of for the purpose of preventing the imposition of such tax through the medium of permitting such gains and profits to accumulate instead of being divided or distributed, and the fact that any such corporation, joint stock company, or association is a mere holding company, or that the gains and profits are permitted to accumulate beyond the reasonable needs of the business shall be prima facie evidence of a fraudulent purpose to escape such tax. But the fact that the gains and profits are in any case permitted to accumulate and become surplus shall not be construed as evidence of a purpose to escape the said tax in such cases unless the Secretary of the Treasury shall certify that in his opinion such accumulation is unreasonable for the purposes of the business. When requested by the Commissioner of Internal Revenue, or any District Collector of Internal Revenue, such corporation, joint stock company, or association shall forward to him a correct statement of such profits and the names of the individuals who would be entitled to the same if distributed. From the fact that this applies only for the purpose of the additional tax, it may be inferred that Congress did not regard as stockholders in interest in the undivided earnings or surplus of the corporation as taxable income in ordinary cases or under ordinary conditions. But the attempt has sometimes been made, under other statutes, to tax such interest as income. Thus, the United States Income Tax Law of 1870 provided that, in estimating the gains, profits, and income of any person, there shall be included **** the share of any person of the gains and profits, whether divided or not, of all companies or partnerships. And there is a Canadian decision to the effect that the undivided profits of a corporation, or a portion of its profits derived from the employment of capital and annually carried into a reserve fund, may be income for the purposes of a testamentary trust, by which it was provided that the trustee might make advances to the beneficiaries out of income. 113 But this is contrary to all the weight of authority. 114 In several of the cases on the subject, it is said that the word income is not broad enough to include things not separated in some way from the principal. It is not synonymous with increase. The value of corporate stock may be increased by good management, prospects of business, and the like, but such increase is not income. It may also be increased by the accumulation of a surplus fund. But so long as that surplus is retained by the corporation, either as a surplus or as increased stock, it can in no proper sense be called income. It may become income producing, but it is not income. 115 Thus, where the profits of a manufacturing or banking corporation have been accumulating for many years, until the market value of the stock is more than double its original price, and the owner dies, directing the income of his estate to be applied to us. Wirtz v. Wirtz, 18 Ontario, 332. In Lawman v. Foster, Iowa, 135 N. Hooper, particular objects. These extraordinary accumulations are as much a part of his capital as any other portion of his estate, and must therefore be regarded, not as income, but as part of the principle from which the future income is to arise. 116 This subject has been fully and conclusively discussed by the United States Supreme Court in the following terms: money earned by a corporation remains the property of the corporation, and does not become the property of the stockholders, unless and until it is distributed among them by the corporation. The corporation may treat it and deal with it either as profits of its business or as an addition to its capital. Acting in good faith and for the best interests of all concerned, the corporation may distribute its earnings at once to the stockholders as income, or it may reserve a part of the earnings of a prosperous year to make up for a possible lack of profits in future years, or it may retain portions of its earnings, and allow them to accumulate, and then invest them in its own works and plant, so as to secure and increase the permanent value of its property. Which of these courses shall be pursued is to be determined by the directors, with due regard to the condition of the company's property as a whole, and, unless in case of fraud or bad faith on their part, their discretion in this respect cannot be controlled by the courts, even at the suit of owners of preferred stock, entitled by express agreement with the corporation, to dividends at a certain yearly rate in preference to the payment of any dividend on the common stock, but dependent on the profits of each particular year, as declared by the board of directors. Reserved and accumulated earnings, so long as they are held and invested by the corporation, being part of its corporate property, it follows that the interest therein, represented by each share, is capital and not income of that share, as between us. Appeal, 28 Pa. St. 368. The tenant for life and remainderman, legal or equitable thereof. 11t. But it is not only on general principles of law that this result is reached, but decisions to the same effect have been made under the earlier income tax laws. It was held that undivided earnings of a corporation are not taxable as in come of the stockholders. 118. And the Supreme Court, construing the provisions of the Income Tax Act of 1870, laying a tax on all undivided profits of corporations accrued and earned and added to a surplus, contingent, or other fund, held it to be plain that it was the intention of Congress not to subject to that tax profits of a railroad corporation during the year, which were not divided but used for construction. 1 1956. Right to subscribe for new stock of corporation. It is a familiar rule in the law of corporations that when a company issues new stock, or stock previously held in reserve in the Treasury, it must first be allotted to the existing stockholders, each being entitled to take his proportionate share at a price fixed. This price is usually and properly the par value of the stock, and if its market value is greater, a considerable advantage may accrue to the share holder, who may either take his new stock and sell it at a premium or sell his right of subscription for it, and indeed the sale of these rights is a common occurrence on the stock exchanges. The courts all hold that the gain realized by a stockholder, either from a sale of the privilege or from its exercise and the subsequent sale of the stock at a profit, is capital or principal in his hands and not a part of his INH 7 Gibbons v. Mahone, 136 U.S. 549, 10 sup. 500. 120. Thus, in a case in Pennsylvania, it appeared that a testator held stock in the B. Railroad Company, which, in order to extend its line, organized another company, with sufficient capital stock to build it, and the unbuilt line was mortgaged for a sum sufficient to build it, and the B. Com. Pany issued bonds for the amount secured by the mortgage, and such bonds the stockholders of the B. Company were permitted to take at par, in proportion to their holdings, and the capital stock of the new company was thrown in as a bonus to those who subscribed for the bonds. It was held that the premium at which the option to subscribe to the stock of the new company was sold was principal, and not income from stock of the B. Company. 121. But under the income tax laws it might be argued that the premium obtained by the sale of a stockholder's subscription rights, though it is not income, may be described as gain or profit, and so be taxable, especially where the statute, like the Act of Congress now in force, taxes gains and profits arising from the sale of or dealing in personal property. But in the absence of any decision on this point, the opinion may be hazarded that such a transaction is not within the spirit or the equity of a statute purporting to tax incomes as its principal feature, though it might come within the literal meaning of the language employed. 57. Sale and distribution of assets of corporation. A distribution among stockholders of the assets of a corporation, upon its dissolution or preparatory to dissolution, is a return of capital, at least to the extent of the original in 120 Lawman v. Foster, Iowa, Con 66, St. Vestment, and not in any sense income in their hands. 122 Thus, a fund resulting from sales of materials, manufactured articles, products from the land, or the general personal property of a corporation, all indicating a final winding up of its business, cannot be called income of the stockholders when apportioned among them. 123 And where a corporation sells part of its original franchise and property, and distributes the proceeds of the same as a dividend among its stockholders, such dividend is to be regarded, as between a life tenant and remainderman of part of the stock, as capital, and not as income. 12 122 In re Thompson's estate, 100, Chapter 6 Persons and
That's it, guys. For now, we've got more videos coming. We're only about 25% of the way through. And low sodium V8. Just a little bit of purified water in there to thin it out a little. Um, so for some of y'all, these are going to be long. They're going to be boring because we're talking about tax, and nobody really likes to listen to tax stuff. But if you've been listening, you've been hearing some key elements in there. I'm taking these elements and I'm going to make my IRS pack for those people who are having tax problems. Now, for some people, depending on what it is, we can help, can do a consultation. This does not mean we're tax professionals or have all the information, blah, blah, blah. It's only advice, private consultation, education. But if it's based on what we're talking about here, we've made a number, numerous videos where you should be able to do things right. But remember, guys, you can't just stop paying taxes because you got a little piece and you heard a little bit of fraud or a little bit of this. You have to uncontract. Okay, think of it as a train that won't stop, can't stop, won't stop. Right? You have to switch railroad tracks. The train ain't gonna stop, so you have to switch it at the right time and account for it accordingly. You can't just pull the brakes and think that the train's gonna stop right here. It's not how it works. So you guys take care of yourselves. Um, that's it for today. I think I may do some more recording later. We'll see. But we will finish the series. And then this series of a treatise on income will be in the courses video playlist. So you'll be able to find that on my main site, which is YouTube. I'll talk to you guys later. Oh, don't forget to support me on blacksite32.com, jamesclovett.com, and you can find me under at James C. Lovett on TikTok or the Badwolf. You'll find me out there. I'll see you guys later. Run wild, but don't be a belligerent or combatant, and I'll talk to you later.